Take our seats. We're going to begin here shortly. Clerk, would you take the roll, please?
Mayor Baxter.
Here.
Commissioner Flores. Here. Commissioner Marino.
Here.
Commissioner Powell.
Here.
Commissioner Sachs. Here. Commissioner Weiss.
Here.
Vice Mayor Woodward.
Here.
Thank you.
We are going to do the invocation and the pledge. If Commissioner Flores would please lead us in the prayer.
All right, let's see. All right, everybody, bow your heads. May we approach today's business of task of faith to do our best within our power to provide positive leadership on behalf of the community and those who live and work here, and that our decisions meet the standards of the divine compassion for all. Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Administrator, do we have any additions, deletions, or substitutions?
We do not. Thank you, Madam Mayor.
I'll entertain a motion to adopt the agenda.
So moved. Second.
I have a motion by Commissioner Weiss, a second by Commissioner Flores. All in favor? Any opposed? Please see that that motion carries 7-0. Moving on to the regular agenda. Is staff doing a presentation on item number 3?
Good morning, Mayor. Yes, item 3A1, very brief presentation. We are back with the board following your direction from October 30th on a potential minor redistricting involving districts 2 and 7 in your backup, and then the PowerPoint presentation got some maps which identify the areas involved. Would tell you that in the course of redistrictings that take place, you always look for roadway boundaries, canals, bodies to keep districts as tight and concise as possible. That was the case in the effort we performed in 2021 of redistricting. So if you look here, you'll see the area notched in red, the diagonal red. The blue boundary identifies Century Village. That was kept in District 2. The notched out piece above lies above a canal, which serves as the northern boundary for Century Village. When we performed the redistricting, we used that canal as the natural boundary. So it was removed from District 2, included in District 7. You can see the population change that would occur should the board direct.
Excuse me, Pat, for clarification, could you explain which district we're talking about redistricting?
Removing the diagonal red properties from District 7, including them in District 2.
Board of County Commission districts.
Only board districts. That's the only thing we're talking about here.
Thank you.
Sure. And that, our count is a population of 119 people in that red hatched area.
And what prompted this?
So we received the board received a email from Century Village Precinct leader, and I'm looking at Commissioner Weiss, he'll remember better than me, Century Village representation, there was representation from both parties, is my understanding, brought this issue to bear. I will point out as well, we went back and looked at districts prior to 2020. This property was included in District 2 at that time. So this change did move this small piece of property from District 2 to District 7. So this prompt came about. We've begun taking a look at it. Board directed us to come back.
Thank you. Commissioner Flores, you're recognized.
Good morning, everyone. Staff, thank you for looking into this. Personally, I'm not a big fan of going, halfway through. We look at this every 10 years, and I don't think we've done this in the past, where halfway through we've made based on a personal request to change somebody out of a boundary right before an upcoming election. I'm not a fan of doing that at this point in time. I think if we want to reconsider this when we go through the normal process, I think we do this, every 10 years?
Historically, we've done it every 10 years in concert with the census, which
Right.
occurs every 10 years.
While I understand what their concerns are, I think we should probably wait until such time where we redraw boundaries in 2030 or around that time frame. But I think at this point, I don't think it's necessary to make this change halfway through our process. So that's where I'm at. I understand their concerns. However, if we start doing this now, what's to prevent other communities to come and do the same? And if we're going to be fair and transparent, I think we got to do that across the board. And to do one ad hoc, I don't think does that. So I would prefer to wait until we do the redistricting, if we do that in the upcoming, after the census. Thank you.
Commissioner Weiss, you're recognized.
Thank you very much. So this was brought forth by the people who live in Century Village, both the people in the impacted area and the people in the rest of Century Village. For the last, I don't know how many years, probably since the existence of Century Village, they've always been included as one community. And we have both the Republican representation from Century Village and the Democratic representation, who very rarely, I shouldn't say that, I'm sure they agree on lots of things, but in this case they came together asking that we correct this, which I think was most likely just an oversight on the part of staff when they drew those lines. And in fact, really interesting to note was the last election for this, we had a candidate who filed to run for District 2 who lived in that area, not realizing, is not eligible even to run in District 2. So while I appreciate my colleagues' comments, I think that at this time, this is something for the people we can address. Government is here to serve the people. In this case, they have asked us to please do this. We have the ability to do it. It's a minor change, 100 and some odd people. Impact is very minimal. So I would like to ask and move this forward that we do this. I have one question for staff, and that is that this needs to be done prior to the primary, so there's no confusion as to if people were to get a primary ballot and then at the general get something different, that would be confusing. So let's make sure we get it done before the primary.
And just to clarify that point, we would have to complete it 270 days before the next general election. So that's a February 6th. Backing the dates out, I have them up there for the board to see. January 6th, if the board directs, we'll be back to you, permission to advertise at the BCC zoning hearing in January. We would be before you to adopt. Then we have to, per statute, advertise it in 2 consecutive weeks. To make all that fit before February 6th, that's the schedule. We have.
It's my birthday, by the way.
There we go.
You can make me happy.
Okay, I have a motion motion, and I have a second by Commissioner Sacks. Are you seconding his birthday or his motion?
Actually, it was his birthday, but I mean, if there's, I know that if there's any other discussion, we should
Yes,
have it, but I do second both.
Okay. Commissioner Powell, you're recognized.
Thank you, Madam Mayor. And I took a look at this, and listening to Commissioner Flores' comments as well as Commissioner Weiss's comments, I do have a few questions. One of the concerns as I reviewed this was the idea that this could be considered mid-year redistricting, right? We do the census in 2020, or every 10 years we do a census, and redistricting is done in the even year after that. We'll be approaching 2026, which would kind of put us in a position where we would be doing almost mid-year redistricting. Commissioner Flores did bring up a point. What if there are other districts where they found or they review the maps in detail and say, hey, look, we've been in District 1 or 2 before, and now we are suddenly in this district, and it's halfway to the point where we would do redistricting, or the census would be again in 2030. The question I have is, looking at the information on the map that was provided to us, Patrick, the demographics in terms of population, the population data, is that based off of the 2020 census, or is this updated data maybe from Bieber or from the American Community Survey, or is this just data from 2020?
Couple things, Commissioner. It's the 2020 census information. The first question I asked the consultants that we worked with in 2020 was, can we use 2020 census information in 2025, 2026 effectively? And we were told, yes, that is viable. That is a valid data source that's out there.
Thank you for that. Which brings up another concern. If we are doing that, we don't know how much the districts have shifted since 2020, since we are in 2025 and 2026, presumably in the next month, what the districts look like now in terms of population. So because we do censuses every 10 years, there could have been a lot of population shifts. The second question I would have is, previously, was all of Century Village inside of District 2? Has any part of Century Village ever been in District 7?
Yes, the subject area, meaning all of Century Village, was completely in District 2 prior to redistricting that we performed in 21.
Thank you for that, Patrick. Can you also, you spoke a little bit, you and I had a conversation with regard to the deviation and the percentage of deviation. Of course, as you just indicated, the deviation is based on 2020 census data. But for the benefit of those of us who are here, as well as those who may be watching in the audience or from home, can you explain what this deviation pattern actually means to us in these specific districts?
Certainly. Short story, you would want to take the population you're working with at the county, divide it by 7, and that establishes a number. You want to keep each district ballpark. This is not a hard and fast number, but generally speaking, you want to keep it within 5% of each other. Don't want to fall outside of that mark. That derives from our work with our redistricting experts who we worked with previously, who I'd want to bring on board should the board give direction. So that 5% number is the standard that's used and the number that we applied in 21.
Thank you for that.
Are you finished?
I think I'm finished. I don't have any further questions. I don't think I have a major issue with this, other than the fact that we would essentially be doing mid-year redistricting, which fundamentally I have a problem with mid-year redistricting. I don't have a problem with a particular area being represented in one district or another. And I think people should get the representatives or the representation to represent them. But I have served in the legislative body where I have seen, after redistricting, some communities have been split, or some communities, based on the boundaries of where they're at, have been put in different districts. So I keep that in mind as we prepare to look and move forward with this particular change. I don't think it's a major issue, other than fundamentally, I'm not a fan of mid-year redistricting.
Thank you, Commissioner Powell. Commissioner Weiss, you're recognized.
Yeah, Thank you, Mayor. And thank you for those comments, Commissioner Powell. Just to clarify, this area, those homes, the condominiums that are there have been there for, I want to say, since the 70s. Is that right? Yeah, the 70s. So there's been no change in the number of condos that are there, or the makeup of 1-2 bedrooms that they have there. So I don't think they're, even though I understand the point of asking about when the census was taken, there hasn't been a big shift in population. This is not possible because they've been there for so long. We have some folks from Century Village. I don't know, Mayor, would it be possible for them to speak on this?
Is this a regular agenda item?
It
Have they
is.
turned in any cards?
Do you have cards? One.
We'll take the one card then, since it's a regular agenda item.
No. Okay.
No?
And Commissioner Weiss, understanding that there may not have been a change in this particular area of where the people are, we are taking into account when you do redistricting, you look at the district as a whole. Have there been changes in the entirety of the district, not just spot, what we, in the world of zoning or planning, we call spot zoning, spot planning, spot districting? You would kind of encapsulate the entirety of where the whole district is. I know in all of these districts, there have been new developments, there have been new units have been constructed, multifamily. So if we're looking at it comprehensively, we're not just looking at a particular area, because I can tell you a lot of spots in a lot of districts may be exactly the same as they were 40, 50, 60 years ago, but the district as a whole, the boundaries of each district, I'm sure there have been, we've approved new developments, we have approved things being demolished and things going away. So it's not just one particular spot, it's the entire comprehensiveness of the entire districts.
Understood.
Thank you.
Commissioner Sacks, you're recognized.
Thank you, Madam Mayor. And I understand what Commissioners Powell and Commissioners Flores are saying. So I'd like to hear from staff, like the specific reasons why this would be acceptable for us to do this.
I would tell you that the geographic presentation, if you will, if we were doing the overall redistricting right now, this would easily be included in the property. When we
So
were-
it's as in redistricting, it's in a specific area that is all of one district, right? Is that what
You
you're saying?
look to maintain continuity between
Okay.
communities, cities,
Exactly.
using those natural boundaries to try and keep the lines as clean as possible. I can tell you in '21, we took Lake Park, it was in 2 districts, created that as 1 district. We took Palm Beach Gardens, which had annexed property going south of North Lake Boulevard, included that in the city. So there are a number of ways that it will present differently. I would tell you that if we were doing the overall redistricting today, this would be returned.
Number 2, do the people want it? Is there anything else other than the fact that it is like the village of Gulf, for example? It's a small little village, but it's like a square, and it is one particular district. Is that what you're saying is the same thing here for Century Village?
The difference being this is just a community within the area, but I would, again, say we would seek to include, like any other large PUD, for instance, we would not want to split it up in any form or fashion.
Could you give us how it was? I mean, I seconded this, but I can see that there's some issues about it. How did it come so that there would be 2 different county commission districts in this one area?
When we performed the redistricting in '21, we looked for as many natural boundaries, roads, clean lines as possible. However it occurred, this one didn't jump out as a challenge in that it would split effectively a community. We used that water body, that canal, as that natural boundary, which, go back to the map, you can see the water body covers probably 80% of that northern boundary. We did that in a lot of places, trying to create lines and clean things up. This just did not fall on our radar as splitting a community. when we were doing the overall countywide redistricting.
There wasn't any compelling reason why this happened historically. It just slipped through, so to speak.
Other than to maintain a strict line, because notwithstanding this little piece being above, the boundary line for District 2 was a straight line then using that water body.
I like to listen to and respect the wishes of the district commissioner, but if there's any other issues that my colleagues like to bring up, I'm certainly willing to listen. Thank you, Madam Mayor.
Thank you. Commissioner Flores, you're recognized.
So I want to make it clear, I don't disagree with that particular piece going back into District 2. I think what my hang-up is the time and the process for which we redistrict. What is going to stop another community who may have been very similarly put in a different district, or they don't want to be no longer in that particular district, or whatever the case may be? What is the process for which a community can now come before us to ask to be redistricted into another district? Because what I'm sensing is that you put a request and we are now making changes ad hoc as we so choose. So I guess my question is more as from a process standpoint, how are we gonna prevent this from happening for the remainder of the next 5 years before we go through this process all over again? So from my standpoint, it's not so much that particular community going into District 2, it's more about the process for which this comes up to us to be redistricted halfway through.
Simple answer, that would be the board's direction on whether they want to contemplate another change. I can tell you that back in '21, when we performed the redistricting, I can look at 3 of you who were here at the time, we developed the first maps, met with all the existing commissioners, walked it through. The maps that we started with to what ended up, the resulting maps, looked radically different. We worked with each district. To your point, Commissioner, I can only presume every commissioner looked back at their districts, got feedback from residents, communities in the area, et cetera, brought us ideas. We made changes. In the short term, this is board direction. Bigger picture, once 2030 census is complete, we would initiate the overall redistricting process, which I know will include a lot of changes and tweaks and modifications.
Okay. I still, I'm not in favor just because of the process. Thank you.
Commissioner Woodward, you're recognized. Excuse me, Vice Mayor Woodward.
Thank you, Mayor. Commissioner Flores brings up an interesting question. I was just wondering, could you tell us, has this happened before? Has this board done a midterm redistricting?
I've been part of 2 redistricting, and to my recollection, have not made any changes in between the normal 10-year cycle.
Okay, and our supervisor of elections is in the room. I was just wondering if she wanted to weigh in on this or to help us understand any repercussions that come from this. Would you, Madam Mayor?
Do you mind coming up, Supervisor Lang?
Thank you. Just if you would give us a full understanding of what this vote would actually do and how any changes would come from this,
Sure.
from your perspective.
As you mentioned, it's only 119 voters or people in there right now. We would then, because currently it is a separate, not only a separate district for county commission, but it's also a separate district for the school board. So from our perspective, it would still stay its own precinct unless the school board also switched districts. So it would really not be any change. I mean, we'll obviously change the district maps, but we would, from an elections perspective, it would still be its own separate precinct, which is a very small precinct, which we don't like to have, both for cost reasons, and then also when you have small precincts, you have a larger chance that you fit into that between 1 and 29 voters voting in a particular method, and then we can't show the transparency that the voters like to see. So if both changed, we would combine that back into the previous district or precinct it was in. But if both don't change, it's going to stay the same. Our big question is simply if they did both change, we'd want it to be before the primary, so that we're not, because there wouldn't be physically enough time between the primary and the general, because we have to come before you twice, and based on the dates, you would be giving your approval I think at the end of maybe September, if you did it back, for the precinct changes, and we would have to have the ballots out 3 days after that. So there just wouldn't be time.
Are they doing the process for the school board as well?
My understanding is no.
Was both of these were changed? Was it under a same school board and a county commission before the last redistricting?
I don't know that.
Oh, okay.
Now, if I can clarify one point, when we did redistricting in '21, we worked closely with the school district, shared a lot of information, but the boundaries are not the same. There are a number of distinctions between the two, but I've been in touch with school district, let them know that this was potential for board direction, this is out there, shared with them what we may be doing.
Okay, all right, thank you. Ms. Link. As far as my opinion, I mean, I don't know, I'm a little torn on this, but only because, I share Delray Beach with Commissioner Powell, and we both share Boynton Beach with Commissioner Weiss, and I know for areas that have multiple commissioners, it can sometimes be a challenge. So I understand a small community wanting to just have a commissioner that they can go to as their district commissioner. So I do respect that they're asking for this, and they had it before. So I'm inclined to support, and if Commissioner Weiss wants to move this forward. But yeah, I would be very hesitant on anything in the future coming back, but this does seem like a unique situation. So I would be in support of it, but I don't really want to see more of these coming in the next 4 years. Thank you.
Commissioner Powell, you're recognized.
Thank you, Madam Mayor. And of course, Patrick, I agree with this on its face. One of the other concerns I do have, though, is if these maps were looked at in 2021 with the commissioners, and of course, there were different commissioners here at the time, and they were reviewed and sent back in terms of the district boundaries, I would kind of have an issue with if all these districts were looked at by the commissioners who were here at the time, and their input was used to create these maps, and this was missed, which seems now today as a small oversight, but back then when you had a different set of commissioners and this happened, then we're coming and fixing it mid-year with the new commissioner. That also gives me pause. I'm glad that we're having this discussion here today because on its face it seems pretty cut and dry and straightforward, but when we have the opportunity to speak amongst each other in public, I do see some of the discrepancies that could be challenging. Again, on its face, it seems very easy and cut and dry. However, the challenge is for me fundamentally the mid-year redistricting process. And then second, the question of how did the commissioners who were here at the time and commissioners who may still be here have the opportunity to review and not catch something that would have looked like a simple error and bring it forward 3-4 years later in the middle of a term where we'll be doing a census again in 2030. So that's a challenge.
Thank you, Commissioner Powell. I'm going to ask a couple questions. Was this resident-driven? Was it brought to us by the residents?
Yes, it was.
And it seems the district commissioner is supporting this?
Yes.
I believe we're here to help residents accomplish goals. And if this is important to them, and it's 119 voters, and we do have an election cycle, and we have timelines to consider, as Supervisor Link said. I am also divided on this. Are there any other neighborhoods potentially that could have a piece like this? I guess I just don't buy into, and I disagree with Commissioner Flores on the idea that all these other neighborhoods could come to us, because, I mean, this is a very specific part of an overall neighborhood that isn't, it's divided out of this neighborhood. So I'm trying to wrap my brain around how many more potentials could be coming to us.
I hate to say it, this one is extremely unique in that we changed something for what existed before, and it's part of the Century Village community. To your question, are there others that could make the case? I would argue not the exact same way, but could be before you and make a case for it in other ways. As I look back to what we did in '21, working with a number of communities and moving boundaries around, we took a number of things into consideration. when you're here for the next redistricting, you will find that it is a massive effort and looking through every nook and cranny. I would tell you that I have not received any prompts or questions or anything of that sort once we performed it. This one is very unique.
Thank you for that. And so that's where I'm having a hard time on this, because yes, again, I don't want a lot of these coming through to us, but I do feel this is unique, and I do think we should be helping residents. The district, so unless the other district commissioner that this belongs to was adamantly about keeping them in his district, then I would like to support somebody who's trying to help their residents is where I fall. And I do have Commissioner Sachs, you're recognized.
Thank you, Mayor. I think you make a very good point. The residents want it. And another thing, and I know that Commissioner Powell has probably sat on a Senate statewide redistricting commission, which brings in a lot of factors. I think that this is, and I understand that, and I respect that, but this is 112 or something Century Village constituents. And one thing that's very important, one, as the mayor said, the residents want it. That's what we're here for. Two, the continuity of interest is here. They're all Century Village. So what their interests are all part of their community, and they should be part of that community. So, and of course, the district commissioner wants it. I respect Commissioner Flores and Commissioner Powell. I don't think we should have this as a standard operating procedure that anybody wants to go and jump in another district can do that. However, this particular one should be judged on its own facts. One, the people want it. Two, it doesn't upset the commissioner of elections. And two, the supervisor of elections. And two, they have a continuity of interest. And I think that's very, very important, and that's why I would support it. Thank you, Madam Mayor, for those remarks.
Thank you. We have no more lights. We do have a motion and a second, so I will take a vote. All in favor, say aye. Aye. Any opposed? Aye. Nay. All right, please see that carries 5-2.
Mayor, may I please have the names of the opposing votes?
The opposing vote was Commissioner Flores and Commissioner Powell. Next, we have I will entertain a motion. I do not believe we need a presentation for item B1, which is a motion to receive and file the warrant list backup information. I have a motion by Commissioner Powell, a second by Commissioner Weiss. All in favor? Any opposed? Please see that motion carries 6-0. On to regular agenda item 3C1, Palmtran. Mr. Von Laren, do we need a timer?
Thank you, Madam Mayor and Commissioners. This is an item that we moved from last week's agenda. We just didn't have the original signatures on this agreement, so we put it today. But just for the record, the Lively Technical School is a Florida Department of Transportation designated maintenance training school. They have them in various locations around the state. They have asked Palm Beach County if we would be willing to house one of their training schools for 2 certifications for heavy-duty maintenance of our bus mechanics. We will be housing this particular program at Belglade, at our Belglade site, so we'll have an opportunity in our county for individuals at no cost to us to have training perform there. Those individuals also will come from other locations to be trained there, so Miami-Dade Transit, Broward County Transit as well, and they'll be covered under those liabilities of those partner agencies when they're here getting that training. So So the expected move-in date is sometime in January or February of this year, so we think it's a really great opportunity for us to have this right in our backyard and offer that training to a number of our residents as well as others. So that is what this agreement codifies between us and DOT, Madam Mayor.
Motion to approve?
I have a motion. Do I have a second? I have a second by Commissioner Marino. All in favor, say aye. Aye. Any opposed? Please see that that motion carries 6-0.
Thank you.
Excuse me, 7-0. We are moving on to our workshop portion of today's meeting, and we will start with the Palm Beach County Park Airport. (3B1). D1. Oh, excuse me. We have one more. County Attorney. Would you like to? Good morning. Mr. Audi, yes, please
Sorry.
check your mic.
By the way, with me is Assistant County Attorney Ann Helfand and our outside counsel who handles all the aviation matters, and it's our expert on all aviation matters just happened to be here for the workshop, so he'll help with this item. So on November 18th, Commissioner Weiss asked the county attorney to review and bring back the options that we have, or legal options, with respect to the relative flight restrictions from the FAA over Mar-a-Lago. And the outside counsel has a short presentation to make just to give us what our legal options are. There are not many, there are two. One is to really do nothing and just try to, as far as the legal process, and try to reach out to have a conversation with them. We've been trying that. That has been unsuccessful, both with the FAA and the Secret Service. And the other option is to start the process for litigation. And we have the option at that time, after we file, we have a deadline of this Friday to file that initial pleading to start the process. During that time, we can wait to see, ask them if they're willing to toll, so we don't have to proceed with the litigation, if they'll come to the table to talk with us. But we have to preserve that right, so we have to file by Friday to try to engage in that conversation. But I'll have our outside counsel give you a little more details with that.
Good morning, everybody. My name is Stephen Ossett with Kaplan Kirsch. Great. So as you know, in late October, the FAA promulgated new flight restrictions. There's a couple of different components to those restrictions. First, the area within a 1-mile radius of Mar-a-Lago was designated as national defense airspace. That effectively prohibits all operations directly over Mar-a-Lago. The Air Traffic Control Tower implemented interim amendments to the arrival and departure procedures at PBI, which is routing all eastbound departures north of Mar-a-Lago. And the FAA has also commenced action to formally amend the arrival and departure procedures to permanently avoid Mar-a-Lago. We were asked to evaluate litigation options to challenge those restrictions. The vehicle for doing so is called a petition for review. That needs to be filed within 60 days of the administrative action that's being challenged, which means effectively that the petition must be filed by the end of this week. It's a pro forma filing. It doesn't indicate what any of the arguments are. It's just a filing to start the process. It's heard initially in the United States Courts of Appeals. It's not a trial. It doesn't involve witnesses and testimony. Instead, the administrative action is reviewed on the strength of the administrative record, which is the documentation that the agency has relied on in making its decision to promulgate the restriction. And here we would anticipate that a challenge in a court would mostly focus on two questions. One, whether there was substantial evidence justifying the need for a permanent restriction over Mar-a-Lago that's in effect 24 hours a day, 7 days a week, regardless of whether the president is in residence. And two, did the FAA follow all required procedures in adopting that restriction, both its internal procedures as well as other statutes like the National Environmental Policy Act, National Historic Preservation Act, which requires agencies to consider the impact on resources when they're making those types of changes. Very important to consider the possible outcomes of that litigation. Although, we believe that there is a reasonable likelihood of success on those questions that I just mentioned. What does that do? So the first is we know that once we file a petition for review, the agency would be required to disclose the administrative record. That is the basis for its decision to implement the restriction. If the arguments were ultimately successful, the court would likely remand to the FAA to either come up with the evidence or to follow the procedures that it was required to follow in promulgating the restriction. But very importantly, the court may be hesitant to order what's called vacatur, which is essentially removing the restriction's legal force and kind of restoring the situation to what it was before. Because there has been a trend in these types of cases for the courts to consider the impact of undoing an administrative action. And particularly here where there are national security concerns, where the FAA will have by then made formal charted amendments to the procedures. The courts may be hesitant to undo all of that, and in that circumstance would order the FAA to conduct all of the required disclosures and procedures and investigation that it ought to have conducted, but would leave the procedures in place while the FAA did that. Again, not a guarantee, but it is a substantial possibility. The non-litigation option is to continue engagement with the FAA and with the United States Secret Service. In fact, we would recommend doing that regardless of whether or not the county determined to file litigation here. And that can be through direct outreach efforts, either directly by the county, through the congressional delegation, other avenues. There's also opportunities to submit comments as the FAA continues to work through its process of developing formal and permanent amendments to the arrival departure procedures. Indeed, the Department of Aviation has submitted written comments on the FAA's development of those procedures already, urging it to comply with its various procedural obligations. But of course, if a petition for review is not filed by the end of this week, this becomes the only option. There would be no opportunity to come back to the FAA in the event that discussions ultimately failed to produce acceptable results. And with that, I'm happy to answer any questions you may have.
Commissioner Weiss, you're recognized.
Thank you. First off, I just want to put on the record that myself personally, but every person that I've been in contact with and have heard speak on this issue 100% supports the need to protect the president when he's in residence at Mar-a-Lago. And we have lived with those flight restrictions, those temporary flight restrictions for 4 years in his first term. We lived with it while he was a candidate and early on up until just the end of October when they put this in place. So I just want to be clear that we all understand the need to protect the president when he is at Mar-a-Lago. The issue is when he is not at Mar-a-Lago, and in fact in the summertime when Mar-a-Lago is not even open, the need to have these temporary flight restrictions, number one. Number two, that they all go to the north. There is no shared sacrifice, if you will, by allowing them to go to the south, which they always in the past have been able to do. And also the commercial aircraft, which have cleared the security protocols that allow them to travel over the entire United States and around the world, is not apparently been taken into consideration. We have not been able to obtain a meeting with the Secret Service, although my understanding is that Congresswoman Frankel has a scheduled meeting on the 18th. But I think it's very important that we preserve our legal rights as a county for our residents. This impacts District 2, District 7, and District 1. And I think it's important that those rights are preserved so that the filing move forward on Friday. But I think there's other legal options, my understanding, and you all didn't go into it, but there are legal options available to the residents themselves directly as well, because this has an impact on them, their property values, their quality of life. We have historic homes, historic neighborhoods that are being impacted by this. And as you said, the NEPA has not been met. There has no been any as required by law. There is also an environmental impact study that is required by law. That hasn't been done. Many of the procedures and regulations that the FAA has in place have not been followed in this, and was no warning. Nobody was given any heads up that this was coming into play until 2 days before they we got notice that they were doing this. So I wholly support preserving our legal options, and I'd like to hear, other things that might be able to be done on the legal front as well. I know you've mentioned these, but I think there are other avenues as well, because if they're not going to sit down and talk to us, possibly looking at having to answer in court, maybe they would like to work together, because I think there are ways to mitigate this, continue to protect our president, but the way this was done is not following their own regulations, and our residents shouldn't be subjected to it.
Thank you, Commissioner Weiss. Director Beebe, would you mind coming forward, please? Good morning.
Good morning.
What is being asked or presented today? How will it impact our airport?
In terms of filing a petition for review,
In terms of what they're asking, if they're asking to divert planes around Mar-a-Lago?
as far as impacts to the airport specifically, obviously, we are now in legal jeopardy for inverse condemnation claims. We are receiving constant.
What would cause those claims because of the residents that are not normally in an air flight now
Yes.
becoming in the air flight path?
So the flight procedures require a deviation from the traditional departure procedures and arrival procedures, which is a straight out departure on the primary runway. Our noise abatement program back in the 1980s, we went through a process of sound insulating homes, buying homes, making the area within the noise contours compatible with airport uses. Because of that, we've had very, very few complaints regarding aircraft noise within that area because we have mitigated and we've had a very robust sound abatement and noise abatement program. The deviation now is putting all of the aircraft over areas of the airport that didn't previously receive this aircraft noise. So it is causing some issues with regard to a lot of complaints from homeowners. It will, and I'll let Steve refer to this, but I do believe that it will eventually subject us potentially to inverse condemnation claims by residents because they will be claiming that their homes are being impacted by this. It also can impact our arrival rate as well, depending on how many aircraft are needing to depart and arrive at the airport, because we are no longer able to essentially fan aircraft on very, very busy days. What'll happen is air traffic control, when we have a lot of traffic, they will essentially provide alternative headings so aircraft can go to the north, to the south, and straight out. Now we have one option, which is to depart to the north. So that does complicate our ability to accommodate all of the aircraft operations as well.
Thank you. And have there been any discussions at the federal level regarding if we do have to, or if they are going to require us, if we decide not to fight this, any dollars to come to us to help residents do some sound mitigation for them?
There have been no discussions with regard to that. I believe we probably would need to go back through our noise, our Part 150 study. We would need to update that, which does require environmental review to go through that process. It's a very lengthy process. We'll be talking about that for the Lantana Airport. We just wrapped up that process for that small airport. It took us 5 years. So there will be no immediate relief for homeowners within that area if we have to go through those processes.
And it was brought up that we went through this for the first time that President Trump was in office. Are they just asking to divert while he's in office, or are they asking for forever?
We don't know the answer to that question. Right now, the restriction is temporary. It could be implemented on a permanent basis. That would most likely be unusual, but it's not to say that it could not happen. It is a possibility. It did not occur after the last term, however.
I do agree with Commissioner Weiss that we should absolutely protect our president. Where I disagree is that when only applying this to when he's here, because then that would require the burden of having them notify us, which is a whole nother, I think that would be another concern. They not necessarily wanting people to know the president's itinerary of when he would be here and when he wouldn't. Commissioner Weiss?
They know. The TFRs when he's here change. They're not the same as what we have right now. So the cone is a mile out right now, the circle. When he's here, it's 3 miles out. And then there's a 30-mile, another outside ring that's put out 30 miles. So that's all noticed, and we get those notices about a week before he arrives, putting in place that he's going to be here. So no, it doesn't create any additional impact on security.
And what has been the suggestion of staff? Is staff recommending that
We're just bringing back the options for the board to decide which option they want to exercise. The consideration was that if we did file a petition, we could actually ask for a stay for us not to proceed, but at least we preserve the rights before the deadline expire, so that if we're unsuccessful with having any conversations with the FAA or the Secret Service, then we proceed with the litigation.
I guess my last, how is this different now than where we were the first time he was in office?
I think the difference is the first time was what was happening prior to this restriction, where it was only for the times when he was located there. So it was a shorter period as opposed to a continuing period.
And now they want it for all the time?
It's all
It
the
is
time.
all the time now?
Yes. Year round.
And additionally, the inability for aircraft that are operating under a TSA-approved security plan to transit that airspace. Previously, there was those restrictions when the president was in residence. However, commercial airlines or aircraft that were screened by TSA were nevertheless able to transit that airspace. Now, all aircraft, regardless of how they are operating, are not permitted over Mar-a-Lago.
Vice Mayor Woodward, you're recognized.
Thank you, Madam Mayor. A couple of questions to go back to, and maybe this is for Director Beebe, on the flying south versus right now, all the flights are going north. Is that a deviation from the first time as well?
Yes, it is. And it is creating a significant issue because all of the flight traffic is going to that northern area. We've been told by air traffic control that It's not feasible for them to routinely send aircraft to the south. However, it did occur, we're aware of, at least on one day when we were very, very busy. They did get approval, I believe, from the Secret Service to be able to do that. But requiring the air traffic control to reach out to do that in those instances, I imagine is challenging for them.
So the first time, or the previous restrictions that were on the airport did have just like a fanning, but north and south, not directly over?
They did allow them to go to the north and the south.
Okay. And then as also with how it was done previously, besides, you know, just when he was here, because I think probably the change that has occurred is it's also this is now his permanent residence, whereas before, I don't believe he was a permanent resident
It was
here?
his permanent residence during the prior administration as well.
Oh, okay. So I wasn't sure about that. So the changes then, for what this option, I mean, are we trying to basically put a placeholder in for if this needs to go beyond, but really let them know we would like to have some discussions on just, you know, even easing up some of these restrictions or allowing, like you said, the commercial, I mean, I don't like the litigation sends out like, hey, you know, we're suing the president, and I don't really think that's what we're trying to do here. It's not what I'm in support of, but I am in support of us trying to find a way to kind of get back to the previous methods that did work, and at least just to have a discussion with them and moving aircraft south. I mean, there's probably a number of ways that this could be done a little better. And I'm sure, I mean, it's been quiet in the south. I thank you for that, but we can take our share of flights going south too. But I guess that's what my question is on this. If we tell you yes to move forward with this December 12th deadline, what exactly is that going to do? Are we filing lawsuit against the federal government, or are we doing a notice?
The petition is the initiation of the proceedings to file a formal challenge. However, one of the options available to us is after we've filed that, because if we're trying now to have informal conversations and it's not happening. So by preserving that option where we file a petition and say, okay, at least that time we believe they're more likely to come to the table to talk with that pending. But rather than proceeding straight ahead with a litigation, it would be to say, okay, we'll ask them to toll it. So we won't proceed with the actual litigation, but at least have them come to the table to talk. If those are fruitless, then we have the option at that time to proceed.
All right, and I did mean to ask, why December 12th? Why is that date the deadline?
60 days from when it was initiated.
From when they issued the permanent restrictions in October?
Correct.
Okay. Because we're kind of here like, why are we up against the gun here? But I guess that's why. And then just as far as airport operations, are we seeing kind of a contraction on our ability to have more flights? I mean, is that some of what's happening?
I can't say that we're having fewer flights. We have typically had issues related to the TFRs generally. On days before the president arrives, folks know that he's coming, so we get a large rush of general aviation traffic in, which does impact, we end up having delays as a result of that, primarily related to general aviation. When he is in residence, we actually have fewer general aviation flights, so commercial service is actually flowing pretty well. The current TFRs, on very busy days, it does have some impact to our capacity, but we also have a runway construction project going on right now, which is impacting our capacity. Next year, we're going to be coming back with a second runway project because we need to do rehabilitation of our airfields. So every impact to our capacity is something that we do feel, whether it's, you know, a single arrival or, you know, multiple arrivals. But it is something that we do have concerns about.
And as far as the future expansion of the airport with the new runway, if this were to become permanent, how would that affect our future expansion plans?
That's a fantastic question that I can't answer. I don't know. I don't have a crystal ball how that may impact our ability to move forward with that project. However, I think it would be significantly impacted.
I mean, is this something we would have to probably consider, like a redesign, or?
To be completely honest, based on the configuration of the airfield, that is our only option for additional expansion at the airport. Short of moving the terminal facilities, I don't see that there's another feasible option. We've looked at this for many, many, many years, but that expansion of the general aviation runway is our best option, and it may be our only really feasible option.
So that is our only option, but if these restrictions were to become permanent, that option isn't really,
It could be impacted.
okay. All right, thank you.
Commissioner Flores, you're recognized.
So, in the previous item, we were talking about listening to our residents and what they want, and I've heard overwhelmingly that this is affecting a lot of people in the county because of the mitigation that we have done for the flight patterns that we've had, and now we're changing those. So I completely agree with Commissioner Weiss's comments. I think we need to seek and follow our options that are available to include this meeting the deadline for December 12th. I don't think anyone here on this board at the county is debating keeping our president safe. I think that's paramount. But this should not be permanent. This shouldn't be when he's not here. I think we have taken on some of that burden when he is here, and we're happy to do so, but only when he's here. When he's not here, I don't think our residents deserve to carry that burden. And I am in favor of moving this forward. Thank you.
I have Commissioner Sacks and then Commissioner Marino. But before we do that, we're going to take a 15-minute recess, and then we will come back. Thank you, everyone. started. Thank you for indulging the brief recess.
You're very welcome.
Commissioner Sachs, you're recognized.
I have a question I don't know the answer to. Does the President of the United States continue to have Secret Service protection after his term is over? I think the answer is yes.
Usually do.
So would that implicate then that our airport, if he continues to live at Mar-a-Lago, Palm Beach County, would we need to continue these restrictions even after the term is over? Because I think that goes towards our decisions today, because we're not looking at a temporary fix. We're looking at perhaps, or maybe we could ask him. I don't have his number right now, but maybe this is something that we need to look at.
His attorney's here.
Oh, we have an attorney here for the president?
We used to represent him.
Anyways, the bottom line is, I guess the law is that a president continues to have Secret Service protection. I think that if the president has determined that or decided that he's going to continue to live in Palm Beach County, then we need to look at permanent restrictions on PBI, and that may influence our decision today. Okay, thank you.
Commissioner Marino, you're recognized.
Thank you, Mayor. In the agenda, on the last paragraph in the agenda, it says, this option would result in the county losing any opportunity to file a formal legal challenge. So I guess my question is, what do we need to do so we don't lose any options?
File the petition by Friday. That's the only way we preserve the options going forward.
Okay, thank you.
I do not have any more lights, so I will wrap up my thoughts. I do think we should protect our president no matter what. It is a very, very important issue. I also believe we should protect our residents. It looks like if this did go through, there's some noise abatement issues or challenges we would have to face. I do not believe that the FAA or the Secret Service would be asking for this if they didn't find it necessary. They went through 4 years plus. Why now? We don't know the answer to that. So without knowing anything else, I would like to believe this is done for reasons that we don't know, can't understand. I like the non-litigation options. I do understand wanting to keep all of our options open, but Director Beebe, you were firsthand front and center for litigation that happened with the Lantana Airport. And what did that do to our ability to work with the FAA and that funding?
I can tell you that it did have a negative impact on our relationship. I can't say necessarily that we lost funding as a result of that challenge. It did make it exceedingly difficult to work with them on certain items. Whether or not filing a petition would result in any specific action, I can't tell you. Could it impact our ability to compete for discretionary funding? Possibly. I honestly, I don't have a crystal ball. I can't tell you exactly what would occur, but it is a potential.
Unfortunately, we only have a couple days for this decision. I lean towards non-litigation options. There has to be a solid reason why they're asking for this now, after all this time that we are just not privy to. This isn't just suddenly something that somebody woke up and decided to do. This is major impacts to our county, where the president happens to live. So again, I don't want to open up Pandora's box of starting any legal litigation with the FAA, but again, I'm one of 7, and we can definitely take a roll call vote on litigation versus non-litigation options. So I think those are the 2 options presented. Commissioner Woodward, Vice Mayor Woodward, you were first. You're recognized.
Thank you, Madam Mayor. To be clear, and I agree with the mayor, I don't like the litigation option. Is the petition, what is this called? What are we actually?
It's a petition for review.
So can you be like abundantly clear on what a petition for review is?
So whenever you're challenging an administrative agency action of the FAA, that proceeding is initiated by filing a petition for judicial review. All it does is identify the agency order that's being challenged. It doesn't explain why it's being challenged, it just identifies the order. After that filing, the FAA submits to the court the administrative record, why it made the decision that it made. Then you have an opportunity to review that record and file a brief explaining why you believe that decision was insufficient. So it'll be, if the board does authorize a petition for review to be filed, it will be at least 3 months before any arguments against the restriction are actually submitted to the court. This is just a preliminary filing to start the process of the agency submitting the administrative record to the court.
Do we have the ability to do any of that without actually taking this legal route? I mean, can we not submit this to the FAA or the authorities who are making this decision?
No, under federal law, if you are looking to challenge an order of the FAA, then a petition has to be filed within 60 days of that action being taken. Otherwise, the courts are deprived of jurisdiction to hear any challenge. So it's a speak now or forever hold your peace type of a.
So what is it that we have been doing that you said we're not getting the responses? What is it that you have been doing for the past 60 days?
So we have, I believe Commissioner Weiss has reached out to the Secret Service directly. We have as well. We've asked for conversations with the FAA regarding the specific procedures. At the time, there was the government shutdown, so we received the response, we'll talk to you after the government shutdown. We recently submitted comments to the specific procedures through an administrative process. The response that we received from the FAA is that we will review them internally and follow back around after they review our comments. And many of the comments that were made today about the restriction were made in our procedural letter submitted to the FAA.
So this that's been put into place could be lifted by the FAA at some point. I mean, they're saying permanent, but they're not saying.
If the Secret Service determined that they could be modified, the FAA could modify the restrictions. They are temporary restrictions at this point, so they are subject to modification. It is my understanding there is a meeting scheduled with the Secret Service with Representative Congresswoman Frankel. Don't know what the results of those conversations will be. They may be fruitful, they may not. So this is an exceedingly difficult decision.
Okay, I think I agree. I don't like the litigation part of it because I think that just puts us, I mean, we don't like when conversations start with us when it's like, okay, you know, we're under litigation, now let's talk. It just doesn't usually go well. So I'm very hesitant on this, but it doesn't preclude us from continuing the work that you've already been doing. And with the government shutdown, a lot of that was paused. We weren't able to do it. And these conversations definitely can continue, and we can talk to our senators and our congresspeople to help us with this as well. So yeah, I'm very hesitant on the litigation side of it, just because I feel it puts us already in an awkward position to have a more fruitful discussion. So that's where I stand.
Thank you. Commissioner Weiss, you're recognized.
Thank you. People keep talking about litigation. This is not litigation. This is an administrative request for review. It preserves that right to allow us to do that going forward, but it is not litigation. We are not filing a lawsuit against the United States government, the FAA, Secret Service, or any one of them, but we are asking that they abide by their own rules and asking that the judge look at that and see, have they in fact followed their own rules? They haven't. It's clear. So I understand my colleagues' concerns about, and I don't take litigation lightly, but we also heard from our Department of Airports director that we're potentially going to be sued over this as well by the property owners. They're not going to be suing the federal government. They don't operate the airport. The inverse condemnation claims would come against Palm Beach County.
That's true.
And we would then be holding the bag, if you so to speak, to pay those claims. If they're successful, they would fall to Palm Beach County government to pay those claims if they were successful over something that we had no control over, nor if we don't move forward, meaning we're not even going to be able to file our own claims against the federal government for what they've done if in fact the residents are successful. So I think it's by not taking this step, you are losing any legal right to move forward in the future if necessary. And that would, to me, is something that, representing so many of those people impacted, I can sit back and not, I have to support them.
Attorney Adi, would you comment on, it was stated that this is not litigation? Could you clarify?
It's clearly a legal challenge as to the propriety of the decision made by the FAA. So it's, as our attorney said, we filed a petition. They have a responsibility and obligation now to the court to turn over their administrative record. Then we filed a brief. So it's initiating a process.
Do you have to file a brief?
Well, one of the things that, as I mentioned previously, is once we file the writ of petition, if we decide to go that direction, we'd reach out to their counsel to say, hey, we'd like to toll it so we don't proceed, but this is to get you to the table to talk, to explore that possibility. And the posture as it is now is there's no way of bringing them to the table except at their discretion, except for the administrative responses that the airport has done. So that's where we are.
Would it be a potential third option to give you direction to just do a petition for review, but not take it any further without coming back to the board?
You mean if we're unsuccessful, would communication not go any further?
Correct.
It's a possibility.
Ultimately, that would mean dismissing the lawsuit because once the petition for review is filed, eventually the court will order the parties to submit briefs. And if we did not want to do that, the only option would be to voluntarily dismiss the lawsuit and give up the claim.
So this is clearly litigation in starting the legal process of going against them.
Yes.
The only reason I like the petition for review is to get information, more information on why this is occurring, and that is the only reason, because I believe everyone would like to know the reasoning. I am not for litigation ultimately, but I would like to recognize Commissioner Marino.
Thank you. I'm not hearing time frames for all of this. The first thing I heard was 3 months. So what would be, if this is something we moved forward, what is the process and what is the time frame? Because if it takes us a year, we're already at the point where this is going to be lifted. So I need to know the process and the timeframes for this procedure before I could even make a decision.
So it's first of all, it's common for in this type of litigation for parties to seek to change the deadlines, but I'll tell you kind of what the standard rules are. The agency has 40 days after the petition for review is filed to file the administrative record. The county would then have 40 days to file an opening brief. The government would have 30 days to file a response brief. We would have, I believe, 3 weeks to file a reply brief. Then the court would order oral arguments and ultimately make a decision. That decision, it's hard to predict the time frame, but it could very well be 18 months after the petition for review is filed. This is not a quick process.
So if this is not a quick process, then by the time we file and go through the 40, 30, 21, the argument, and then 18 months, we're already past where the damage is done and where our folks have felt all of the impact of this, and we haven't gotten a decision anyway. So I would not be in favor of doing this. Thank you.
Commissioner Powell, you're recognized.
Thanks, Madam Mayor. And the question was answered, is administrative right for review the same thing as legal action? And the answer was yes there. My question to our attorneys and to our airports director, if the federal government hasn't followed its own rules previously, what do we expect to happen from this process?
I think that's better answered by Mr. Offset
Mr.
in terms of what the process would be if reviewing the administrative record, we see what they actually did.
I think that the FAA process to impose this type of a restriction would require compliance with National Environmental Policy Act, National Historic Preservation Act, variety of other statutes. Those statutes are procedural. They require an agency to consider the effects of the proposed action, but they're not substantive statutes. They generally don't limit the options available to the federal government. It just requires them to fully study, understand, and disclose the effects of its actions before taking actions. They're not kind of action-forcing statutes, they're disclosure statutes. So for the most part, a successful litigation here would mean requiring the agency to go back and perform that type of study and make the required disclosures in order to maintain the restriction. It would not prevent the agency from imposing that restriction. The one caveat to that is federal agency actions must still be based on substantial evidence. One of the bases for the challenge would be whether or not there is a sufficient justification for this restriction being in place 24 hours a day, 7 days a week, regardless of residency. Ultimately, the agency would have to support that restriction in order to move forward. But there is, of course, a significant degree of deference afforded to the government on issues like national security.
Thank you for that. Let's move into the area, Commissioner Weiss, and we aren't involved in any litigation with regard to any of our constituents or citizens as of yet, but the issue of inverse condemnation and the real possibility that people are concerned that planes are flying over their house. You talked about NEPA, the National Environmental Policy Act, and some of the other acts that go along with this. Without us being in any type of litigation, but as an attorney, the concern that this could be brought forward as a takings type case, because planes fly over people's houses, but there's an increased number. Does that mean they lose value of their property, or they're no longer able to use it? Is that a substantial claim that could potentially hold up in terms of inverse condemnation? Or is anyone losing the ability to use their property behind this because of the additional air traffic? It's a roundabout question, but it's a significant question because I need to have a better understanding.
Commissioner Powell, is it a threshold question? Where's that threshold?
It is. Is there a threshold to what amount of air traffic or maybe noise pollution constitutes someone losing the ability to, or losing value in his or her property?
I'll be a little careful in answering the question because it's always, a bit awkward to advise in a public setting whether or not the county may face liability for that type of a claim. Commissioner Weiss is correct that the proper defendant in inverse condemnations or takings claim would be the county. The way that the law has developed, the owner of the airport bears potential liability for essentially not acquiring enough property in maintaining the airport, the property here being kind of overflight rights. That's the basis for an inverse condemnation claim. Those claims are difficult to prove. Generally, they require that there be a direct interference with the super adjacent airspace above homeowner's property that really deprive a homeowner of all beneficial use of their property. Generally speaking, and there's a lot of variation amongst jurisdictions in the United States, but generally speaking, the type of exposure to sound that we're kind of all expected to bear as aircraft are flying over our property is not compensable. But that means that whether or not there's a likelihood of success depends on the individual circumstances of each and every impacted homeowner. So it's very difficult to kind of generalize those types of situations, except to say that it is a difficult claim for homeowners to pursue against airports.
Thank you. Vice Mayor Woodward, you're recognized.
Thank you, Madam Mayor. My first question is, because this happened over a federal government shutdown, is there any chance for an extension of the days? Since we tried to initiate conversations and they were shut down, is the December 12th not negotiable for?
So had we had more time between now and the deadline, we could have filed, and we still could file, to ask for them to hold a date for us to initiate the process. Whether or not we'd get a response in time before the 12th to know that. But we could file one today to see if we could ask to get the toll-in of the deadline to some other date beyond and see what would happen. But chances are that we'd get that answer by Friday are kind of slim.
Okay. I mean, this is a very important and big decision for us to make, and I would like a little more time. I understand that deadline, but again, if we initiated some of this and couldn't get answers, and and I appreciate the discussion to say that this is not litigation. We have a 5-page PowerPoint here where the word litigation is 5 times, and in the meantime, I decided to ask my little handy AI, is filing a petition for review with the U.S. Court of Appeals considered litigation? And it's yes. It actually says it's a formal adversarial proceeding in federal court. So this is litigation.
It's a legal challenge of their action, so yes.
So at this point, I think I would ask for us to file for an extension on the deadline so that we can continue the conversation. But as the mayor did point out, and it got me thinking, I mean, there are things that we don't know. And if there is a legitimate reason, and again, this is not something that's going to be told to us or the public if there is a reason for it, but litigation is where we're suing. And it's a big step that I'm not comfortable with.
Commissioner Sachs is the last one. I'm going to recognize you, Commissioner Sachs, and then we're going to take a vote on whether we would like litigate or non-litigation option. Commissioner Sachs, you're recognized.
The litigation issue would be whether there's substantial evidence from the FAA's designation to keep this airspace separate separate as national defense, in contradiction to homeowners whose peace and quiet and the enjoyment of their property is being devalued, is being jeopardized. Is that basically what we're looking at here in terms of whether we go to court? Are those the two issues?
Well, we're only we can only litigate one, and it's how we are affected, not how the homeowners are affected.
So we
That's
as a county,
something that homeowners would have to take upon their own.
so as a county government, we're protecting our PBI, our air, the airport. Is there any possibility that a court would find that we have superior rights to the defense of the President of the United States?
The court wouldn't consider your rights. The question is simply whether or not the agency had substantial evidence and followed the law in adopting the
Substantial
restrictions.
evidence. Now, legally, if we're looking at whether we're going to file this or not, legally, FAA's substantial evidence is that that is where the President of the United States lives, and that area should be protected. Is that correct?
We don't know. We have not given any basis for the restriction and its permanency, or its
Wait a minute,
persistence, I should
We have
say.
not been given any idea from the FAA as to why Mar-a-Lago should not be flown over by commercial jets.
That's correct.
Okay. And in order for us to get this information, we have to file something by Friday.
It is one, if we file something by Friday, they are forced to give us that information. It's not, of course, the only way to get it, but we haven't gotten it through other
There's
means.
another way. I can't imagine that they have not given us this information yet. Congresswoman Lois Franco is looking into this, and in order for us to preserve our rights as to whether the FAA has done substantial evidence, we have to file something by Friday. Is that the bottom line that we're going to vote on today?
Correct.
Okay. So what is the downside of not filing something by Friday?
Simply that cuts off any litigation option you may have in the future.
So if we file something by Friday, we will definitely get information from the FAA, but we will not be able, but we waive our rights to litigation later? Is that it, sir? No, it's the other way around. That's right. So if we file by Friday, we're in a safe position. We get information from the FAA, regardless of what our congresspeople get for us, and we preserve our rights of litigation later if, in fact, we even have substantial rights later. Would that be the question?
That is correct.
Okay, so why would we not want to do this? Any answers? Why would we not want to file something by Friday just to preserve the county government's rights? Is there any downside?
There's no legal risk, in my view, of not
Okay.
filing a petition for review.
This might keep our county lawyers busy a little bit. Today's Tuesday, right? But I think we could do it by Friday.
If we need to file a petition, yes, we can
Okay,
file
it
it by
doesn't,
Friday.
we are not jeopardizing county government's right by doing it by Friday. Correct?
Correct.
We are preserving our rights, and we're forcing the FAA to give us information, which we need as county government and owner of an airport. Correct?
Correct.
Okay. Thank you, Madam Mayor. I just decided how I'm going to vote. Thank you.
Thank you, Commissioner Sachs. Questions for legal. Do you need a motion today or direction? So the motion would either be to proceed with litigation or to proceed with non-litigation? Commissioner Weiss, you're recognized.
Yeah. So I'd like to make a motion that we authorize the two things, actually, in listening to Commissioner Woodward. One is to request an extension from whoever we request it from.
Right.
If that is not responded to by the 12th, that we move forward and file our
Petition.
for review.
Commissioner Powell, you're recognized.
Thank you, Madam Mayor. And can I ask a question while I know there's a motion on the table?
Yes, you may.
Director Beebe, you did indicate that there's potential, I don't want to put words in your mouth, but negative impacts of filing litigation. And I know at one point previously we passed policy and ordinance with regard to diversity, equity, and inclusion to make sure that we didn't lose any grant funding. I don't know if there's a nexus here, but is there a possibility that potential legal action could result in us losing grant funding that may potentially be out there?
So the requirement related to the grant assurances, that we were actually, in order to receive grant funding, were required to implement those actions. So those were tied together very directly. This situation is far less direct, that we do have opportunities to apply for discretionary funding. I cannot tell you how this decision would impact that decision-making process with the FAA.
Do you believe it impacted us when we were in litigation for Lantana?
I don't believe that it did. It did strain our relationship to some degree. It did put us in the situation where they were unable to have conversations with us with regard to certain issues as a result of the fact that litigation was in place. I cannot tell you that we actually lost a specific funding opportunity during that period, though. I can't say that it's not a possibility, however. This is a different administration. I honestly don't know.
Are you finished, Commissioner Powell?
Thank you, Madam Mayor. I am.
Commissioner Marino?
Commissioner Weiss, would you be willing to make two motions? Make that motion first, the motion to ask for an extension, and then have a second motion for if we want to go to litigation? Because I would be comfortable with going for seeing if we can get more time. I'm not comfortable with litigation. So I don't want to vote, and I would like to see them as two separate motions.
I think my motion was to try and achieve an extension, but if that fails and they don't respond, we have to, if we don't get it by the 12th, I mean, we have to file by the 12th. So if they respond in a day or so, then we have an extension. If they don't, we preserve our right.
Would you like to make a
I
substitute?
would make a substitute motion that we file for an extension.
I have a substitute motion by Commissioner Marino. I have a second by Vice Mayor Woodward. All in favor? This is for the extension. All in favor, say aye.
Aye.
Aye. Any opposed? Please see that that motion carries 7-0. This is just for the extension. This is not in regards to litigation. This is just asking them to give us an extension. That was the substitute motion.
But
I will entertain another motion if we would like to, in regards to litigation. Commissioner Sachs, you are recognized.
Well, I think from my memory, Commissioner Weiss made a motion to file for an extension, and if that failed, then to go ahead and pursue preserving our rights under litigation.
But then we had a substitute motion.
Okay, but we had a first and we had a second on the first motion. Am I correct or not, Madam Clerk?
But once the substitute motion is made, then we vote on that. I'm looking to the attorney.
And there's a second to, okay, so there's a second to the, and the second motion, the substitute motion, is to file for an extension, and if we don't get it, we have not preserved our rights.
Now we will vote on if we want to proceed with litigation, whether or not the extension is successful. If somebody makes that motion.
Got my light on.
What-
So Commissioner, do you mind if I go to Commissioner Weiss?
No, go right ahead, that's what we are.
Thank you.
Go ahead.
My motion is to file the notice for the petition for review December 12th, unless there is an extension received.
I second that.
So I have a motion by Commissioner Weiss. Do you need it restated? I have a second by Commissioner Sachs.
Discussion?
Yes, Commissioner Marino.
Thank you. So again, could you please go over the timeframes at which this could possibly, the fastest that we could get an answer?
There would be 80 days from the filing of the petition before we, the county, submitted an opening brief. Another 30 days for the government to respond to that brief. Another 21 days for us to reply to the government's brief. I'm very bad at math.
It's 131 days.
Thank you. After that, it would be up to the court to set a date for oral arguments and ultimately issue its decision. I think the fastest you could possibly expect that to occur is 6 months or so after the briefing was concluded.
After the briefing was concluded. So
Right,
we're
so
talking
100
130 days plus another 6 months?
Plus 6 months, correct.
So we're basically, again, we're pretty much at the October 26th date that they were talking about. So we won't even get an answer in any way, shape, or form for at least another 9 months.
That is correct.
Okay. Thank you. That was my question.
Commissioner Flores, you're recognized.
I understand Commissioner Marino's comments regarding the time frame as the earliest, potentially as maybe 2 years that we can get an answer. But this permanent restriction, does it have an end date?
It does. It was put into effect for 1 year, so expiring October 20th, 2026. We don't know whether that will be extended.
So they could potentially continue to extend it?
That is correct.
Okay. So if we don't put this challenge, could we do the challenge in a year?
You could not, because the action will have already been taken.
Okay. So basically, if this 60 days passes, we lost our opportunity to file our petition.
That's correct.
Okay, thank you.
I have a motion and a second. Commissioner Weiss, you're recognized.
I wanted to make the comment, and I think Commissioner Flores did it for me, but there's really no expectation that this is not going to continue to be re-upped every year.
Vice Mayor Woodward, you're recognized.
Thank you. To what Commissioner Marino was saying first with the timeline for the year, it did kind of trigger a question I would like to ask on, do we have an estimate of the cost for us to pursue legal options for the next year against the FAA?
Difficult without understanding how the proceeding would unfold. It's not unusual for a proceeding like this to, I would say, $200,000 to $300,000 is probably a fair estimate.
Okay. And if they are to say there's a national security reason behind this, we're sort of in unprecedented areas here, and that argument can be made that pretty much will end any discussion. Am I right? I mean, if that is their answer, we're not going to get an answer, are we?
You're right. There's not a lot of precedent for this type of situation. However, there have been challenges to the designation of national security airspace before, and even where courts have been hesitant to second guess the need for that type of airspace designation, they've still required the agencies to follow their own procedures in adopting those airspace restrictions. So the procedural challenges, I believe, are still viable, but you are right that when it comes to whether or not it is necessary for national security purposes to prohibit flights, I think it's very difficult to challenge the restriction on that basis.
Okay.
So we have a motion and a second. I would like the clerk to take a roll call vote, please.
Commissioner Marino? No. Commissioner Powell? Yes. Commissioner Sachs?
Yes.
Commissioner Weiss?
Yes.
Commissioner Flores?
Yes.
Vice Mayor Woodward.
No.
Mayor Baxter.
No.
That's 4 aye, 3 nay.
See, the motion carries 4-3.
Okay.
Thank you.
All right, so we'll proceed with filing the toll-in to see if we can get it stayed and advise the board accordingly.
And the extension.
Yeah, that's the toll-in, yes.
Yes,
Cynthia,
thank
yes.
you. On to the Lantana Airport. We'll start the workshop portion. Director Beatty, thank you for being here. Do you want to give us a brief update on the Lantana Airport and what's currently taking place?
So we do have a presentation. I understand you have a hard stop, so I will try to expedite the presentation. These were we're presenting two very lengthy studies that were conducted over a number of years, so it will take a little while to go through the materials. But I will try to expedite as much as I possibly can, understanding your deadline. For the record, I'm Laura Beebe. I'm Director of Airports. I also have with me here today Gary Sypek, our Deputy Director of Airports, Annie Helfunt, our Senior Assistant County Attorney, Stephen Ossett, who you've met with Kaplan Kirsch, Robert Mintzer with HMMH, and Mary Ellen Egan with ME Consulting, who represent our Part 150 study team, and Patrick Rudder. We'll be starting our presentation today with an overview of the Part 150 process, including the noise exposure map, the final noise compatibility program recommended for the Lantana Airport, which will be followed by an overview of the safety assessment. In order to address community concerns regarding aircraft noise at the Lantana Airport, the board approved the completion of a Part 150 noise compatibility study. A Part 150 study is a voluntary FAA-defined process that consists of two primary elements, a noise exposure map and a noise compatibility program. The Part 150 process requires robust stakeholder engagement. In order to seek input from stakeholders, the department formed two committees, a technical advisory committee and a citizens advisory committee consisting of representatives of the municipalities surrounding the airport, community representatives, airport users, the FAA, and other interested parties. We participated in multiple public meetings and received public comment. The first phase of the Part 150 process requires the development of a noise exposure map, as shown on this slide, which depicts the noise contours based on existing conditions and future conditions. The FAA has established a day-night average sound level, DNL, as the noise metric for determining community noise impacts, and has identified DNL 65 decibels as the metric for identifying significant noise impact areas surrounding airports. Although noise monitoring was conducted as part of the study for informational purposes, noise exposure maps are required to be developed utilizing the FAA's Aviation Environmental Design Tool, which models aircraft noise in accordance with FAA requirements. Residential uses within noise contours exceeding DNL 65 are considered incompatible aircraft noise. The resulting map determined there are no non-compatible residential uses within the 65 DNL contour. However, it's important to note that this does not mean that there are no aircraft operations exceeding 65 decibels. However, that noise is not measured on a single event basis for purposes of Part 150 studies. So the noise compatibility program addresses three major categories of actions to reduce impacts of aircraft noise on incompatible land uses: noise abatement measures, land use measures, and program management measures. Because there are no incompatible land uses within the DNL 65 contour, the noise compatibility plan for the Lantana Airport will not be officially reviewed or approved by the FAA, which means the county is not eligible to receive federal funding for any noise mitigation measures. However, the county may still pursue measures outside of the Part 150 process, provided they're consistent with federal law and our grant assurance requirements. Therefore, the department is recommending the county pursue various measures outside the Part 150 process. Some of the measures, however, would require further study prior to determining the feasibility of implementation, and the recommended measures may also require further review and approval or action by the FAA or the Board of County Commissioners prior to implementation. In some instances may require environmental review as well. It should be noted that the Part 150 process and this process will not result in the implementation of any mandatory restrictions, such as prohibiting flight training or particular aircraft operations, establishing mandatory hours of operation, or other similar actions. All recommended noise abatement measures will be implemented on a voluntary basis in accordance with federal law. The department is recommending the continuation and adoption of various noise abatement measures which are designed to reduce aircraft noise in areas with non-compatible land uses. In evaluating measures, the department considered input from the communities as well as public comments, whether or not the proposed measures provided clear guidance to aircraft operators and could be consistently achieved, potential impact of the measures on aircraft safety, the need for voluntary compliance to ensure success of the proposed measures, and potential noise reduction measures associated with each benefits with each measure. The existing measures were recommended to continue to include retaining runway 422 as the preferred noise abatement runway, discouraging intersection takeoffs from any runway, following established voluntary flight patterns, recommending pilots implement best practices to fly neighborly in accordance with established guidelines, recommending helicopter traffic patterns remain in altitude of 1,000 MSL, and maintaining the existing engine run-up location. The department is also recommending the continuation of existing land use measures to discourage the introduction of new incompatible land uses in areas adjacent to the airport, including retaining the existing land use noise zone and regulated area for educational and residential properties, and to continue participating in comprehensive planning.
Excuse me, Director Beebe, just
Sure.
so I know, thank you for going quickly. At the end of all this, what is it you need from us? What is it you're asking for?
So I've been asked to provide a presentation regarding the final noise compatibility program. I don't need anything from the Board of County Commissioners in terms of approvals at this point. Any measures that require further approval by the Board of County Commissioners will come back individually to the Board of County Commissioners and/or go to the FAA. This is your opportunity, however, to say whether or not you object to any of the measures that we're proposing.
Commissioner Powell, you're recognized.
Thank you, Madam Mayor. I've got two questions. Director Beebe, how can we tell if these noise abatement procedures are effective over time?
So we have an aircraft noise monitoring system, and we have the ability to purchase additional noise monitors as part of our new noise monitoring system contract. So we will be able to monitor aircraft operations and noise through the system, including individual operations and actual noise. We're also, as a part of this program, recommending that we establish a citizens committee similar to the committee established for the Palm Beach International Airport to help us further study some of the measures that we're recommending, in addition to take a look at the potential for new measures and really monitor the activity at the airport and provide feedback to airport users who will also be participating on this committee.
Thank you for that. The monitoring system makes sure that the noise levels are below 65 decibels at all times on properties outside of the airport?
No, it does not do that. It will tell us where aircraft are flying. It will tell us noise information about the aircraft. Noise monitors will tell us noise information about the aircraft. It doesn't prevent aircraft noise. None of these measures will prevent aircraft noise. The intention is to try to reduce the impacts on the surrounding communities by adopting measures that are reasonably achievable.
Thank you. And how will the proposed or the planned Lantana Airport Noise Citizens Committee operate, and under what authority and influence?
It would be an advisory board to the Board of County Commissioners, similar to the Citizens Committee established for PBI. And we're proposing that it be made up of members of surrounding communities as well as airport users, so that they can continue the dialogue on the ability to achieve various measures over time. Because they're all voluntary procedures, I think it's very, very important to continue that dialogue amongst the users and the affected communities.
Thank you.
Commissioner Flores, you're recognized.
So we didn't quite get to the new measures that you're looking to implement. So there are 6 abatement measures that you're proposing, which I am in favor of. There's 1 new land use measure that you're also recommending, I'm also in favor of, and there are 3 new program management measures,
Yes.
which I'm in favor of. So this is in my district. I know we also have the mayor of Atlantis here who would like to speak. So I would like to hear him at some point, and then I have some other comments. Thank you.
Commissioner Weiss, you're recognized, and then we'll hear from the mayor.
Yeah, interesting. I mean, and speaking of redistricting, so understand that the majority of the people impacted by Lantana live in District 2, but the airport itself is in District 3. So, just saying.
Are you asking for another redistricting?
I would not. But I'm just saying that these lines can somehow, on speaking on behalf, and I know our airports have, as operators are very sensitive to the needs of the surrounding residents. On the other hand, because of the way Lantana operates, meaning they are non-controlled airport. So much of this falls on the pilots in charge to comply. And I think, speaking on behalf of the residents, the challenge has been we get some folks either who don't know what the procedures are, or we get people who don't care. And it doesn't really matter to them what the case is. I think ultimately it's how that impacts their lives and their quality of life. I know we're working to get and you're getting new tracking to be able to better monitor the aircraft.
So that's currently in place. With this new committee, we're proposing to have them build out the dashboard so that the community has a better transparency into the actual operations. We also have the opportunity to purchase temporary noise monitors and permanent noise monitors.
Well, I think that's going to go. It's something the community has been asking for years, and I know it takes time. We needed to get this. You wanted to get the study done and the Part 150 done. But it is very important for that. I've seen in other, especially around where the run-ups are, large signage that explicitly reminds the pilots of how they're supposed to be operating. I don't know. I didn't see that. I thought there was something in there, but I don't know that I saw something exactly.
So we are recommending updated signage as part of program management measures. So that's one of the things that will be incorporated in the program.
Yeah, I mean, at airports that I've utilized in the past, they're massive. You cannot miss them. They're not like the little snipe signs we see at the intersection. These are big signs, and there's no way of missing them. So, I appreciate the recommendations. I would also like to hear from the mayor of Atlantis as well. He's very well versed on all of this. And so I'll leave it at that.
Mayor, if you would, please. Good morning.
Good morning,
Welcome.
Madam Mayor and members of the commission. My name is Alan Callback. I am mayor of the city of Atlantis. I greatly appreciate the opportunity to appear before you this morning. And I want to commend the commission and Director Beebe and her team, because we really appreciate the support in trying to address the issues that we have, both with respect to noise, but also with respect to safety. And I happen to serve as a member of both the technical and the citizen advisory committees for both studies. And I must say that we've had a very collaborative approach in terms of trying to work through the issues, especially right now with respect to noise and with respect to the new noise operating monitoring system that's coming in. And we had a very good meeting that included representatives of the airport, the fixed-based operator, and those of us on the committee, and I think we have a way forward, even though there are outstanding issues with respect to noise and the impact on quality of life. I think in good faith, we have a way forward, and especially with the new operating system with respect to noise and operations, that we can find a way to work on things. The safety study is another issue. Once again, commend the undertaking of that and appreciate that the study was undertaken. But with respect to that, and I've gave to the clerk, and you'll have in your mailboxes a copy of a detailed assessment that we had undertaken by our aviation advisor. And this is an individual who has extensive experience both in the military and in the civilian areas. And I think the safety report as it stands is a good start. It identifies the issues, but there's a lot to be done in terms of making sure that we do have safe operations at the airport. And I'll just take a minute, and once again, just to hit the highlights, but you'll have the detailed assessment. And a lot of these issues we raised in terms of our observations on the first draft of the Recondo Safety Assessment. They were not addressed in the report itself, but they, like the noise study, there was a section that said, here are the public comments and here are the responses. But this is in response to the responses. The key conclusions, and you'll see this, is based on a review of the technical portion of the final report and the responses provided in Appendix C. Several safety and operational issues identified earlier by the city and other stakeholders remain significant. The assessment does not identify or analyze hazards. It does not review LNA's accident or incident record, even though the airport has an extensive history of accidents. It does not assign probability or severity to anything that's described. It does not compare LNA,
Please, yes.
It does not compare LNA to similar airports or operational environments. It documents incompatible land uses, but does not evaluate what they mean for actual safety. It avoids human factors, training density, and the real complexity, which Commissioner Weiss was referring to, of the operating environment at Lantana. The conclusion that jet operations do not increase risk is not properly supported by any risk-based analysis.
Mayor, do you have a specific recommendation for this board that you would like to see occur?
Yes, I think the recommended path forward, and that's in this document. At this point, the final report has been delivered, and there's diminishing value in debating what the study should or should have not have done. The limitations, and once again, they're outlined here, and we'd be glad to continue the dialogue with Laura and her team, but the limitations are clear. A more productive direction is to focus on a way forward for the county, the city of Atlantis, and other stakeholders, including other communities, to work together. A jointly developed framework would enable a consistent and transparent method for assessing risk, documenting safety concerns, and participating constructively with the FAA. And then there's an appendix that has the recommended steps, and they're all within the purview of the authority of the Department of Airports under the authority of the Commission. So I'd urge you to please read that, and we'd be happy to provide any additional information. And once again, I thank you for this opportunity.
Thank you, Mayor. Commissioner Flores, you're recognized.
Thank you, Mayor. Laura, do you want to provide any input into some of the comments that were made? I want to give you the opportunity.
So at the very beginning of the study, we actually collaborated with the City of Atlantis on the scope for this particular project. We received input, we incorporated the input, and we've gone through the study. It's my understanding that the city is not necessarily in agreement with the conclusions. However, we do have professional consultants that prepared the report, Recondo Associates, who is here today. Ultimately, they determined that the introduction of jet operations at Lantana does not degrade operational safety or risk at the airport to the surrounding communities or within local airspace. They also concluded that the air traffic control benefit cost analysis, that construction of an air traffic control tower at Lantana would improve operational efficiency and safety. They did identify certain areas where we need to mitigate, including a minor encroachment in the runway 1634's object-free area. We need to coordinate the mitigation of vegetative obstructions, 9 trees on private property off of Lake Osborne. We typically trim and remove trees on an annual basis in order to make sure that we do not have obstructions. I will be coming back to the Board of County Commissioners with recommendations on how to work with the private property owners to mitigate those obstructions without having to resort to code enforcement measures, including providing a program to trim and remove trees at the county's cost. We will also be assessing the runway protection encroachments as part of the ongoing Lantana Airport Master Plan. However, I want to be very clear about the runway protection zone encroachments. 96% of airports in Florida have encroachments within their runway protection zones, including Palm Beach International Airport, with very similar obstructions. If we go down the path suggested by the city and some of these conclusions that they have made, that means that we would need to apply that across the board at all of our other airports, which is not financially feasible. However, that does not mean that there is not opportunities to mitigate certain obstructions within our runway protection zones when it's practical. I'll give you an example. One of our runways has a park nursery building within the runway protection zone. That's something that we can work with the Parks Department to relocate. Other obstructions includes roadways. Palm Beach International, we have major roadways off the end of every single one of our roadways. Most airports in Florida do. So I do want to be clear that we have done a comprehensive study. I believe that we can rely on the findings of the report provided to us by Recondo and Associates. They're a very well-renowned team in this area. I, in my personal opinion, do not see any value in continuing to study these issues repeatedly when we have determined that this does not degrade operational safety. This study was limited, please note, to jet operations as a result of the repeal of the jet ban. It wasn't an overall operational safety review at the airport. There's also a lot of discussion about aircraft incidents at the airport. I want to be absolutely clear, none of those incidents, and we have reviewed them as part of the benefit cost analysis, had anything to do with the condition of the airport. It had to do with either pilot error or mechanical problems, which we cannot change as an airport. That's not something that we have control over.
We can't mitigate for
We
it.
cannot mitigate for that. We can mitigate for airport-related conditions, and as I indicated, as part of the master planning process, we will do that. The encroachment in the object-free area, we're already working with the fixed-based operator to address that issue. So, in my opinion, the issues that we do have are easily resolvable.
Okay. I've been on this board for a little bit over a year, and I've had the pleasure of speaking with you about Lantana Airport on various occasions. I know that this noise study, and you take that very seriously, and that you try to accommodate and be as accommodating as possible, knowing it's an airport. So I commend you on that, on the team, and creating this advisory board. I think that will help sort of bridge that gap between the providers and our residents. You told me early on that the major cause of noise is a helicopter person that operates there, and we can't restrict them. They have every right to be there by FAA rules. But that individual has been very flexible, accommodating. He's tried to do everything within his power to keep the hours of operations within the daytime. And he's pretty much done everything that we could possibly ask of him and his company. So I commend you on that. I also see that we have the provider back in the back. So thank you for being here. In your comments earlier, you talked about a contract tower. You believe that would provide further safety to this airport?
So the report indicated that it would improve operational efficiency and safety. Ultimately, decision whether or not to pursue a federal contract tower would be within the discretion of the board. Most airports in the United States are non-tower airports. This is not an unusual airport by any means. However, if you wanted to further improve operational efficiency and safety, that is certainly a measure that you could direct us to move forward with by filing an application for a contract tower with the federal government.
I believe you're working on a master plan?
Yes, and we would also, as part of the overall master planning process, if directed, identify a location, an appropriate location for an air traffic control tower.
I'm all about safety. I think bringing a contract tower to these facilities would improve our safety. Some of the issues that Commissioner Weiss mentioned about flight patterns. So I believe that maybe looking into this in the master plan is a must. So that would be my ask.
Okay.
Thank you so much.
Vice Mayor Woodward.
Thank you. I just had a quick question about the committee. We had 2 committees formed for the role of the study. Are you looking to keep both committees, the technical and the citizens advisory?
So there are 2 separate studies that were conducted. One was the Part 150 noise abatement study that had 2 technical committees that were associated with that, a technical committee and a citizens committee. Those committees were formed by the Department of Airports. We're asking you to form an advisory board to the Board of County Commissioners for issues related to aircraft noise at the Lantana Airport. We are not asking to form a committee related to airport safety at the airport. Those are 2 separate and distinct issues. And again, the assessment that we had done for the Lantana Airport from a safety perspective was isolated to the introduction of jets. Since the introduction of jets, we have had less than 1% of operations at that airport by jet air traffic.
Okay, so is that something that you will be bringing back to us with like a recommended who you would like on this committee? And
Yes,
then
we will be coming back to the board with a resolution with a proposed makeup for the committee, not necessarily the specific members, but identifying, for instance, you need to have members that are airport users, representing, say, a helicopter operation and a fixed wing operation, which surrounding communities we would want to include in that committee as well.
Okay, good. So that, I'll support that, but you'll be bringing that back to us for a resolution in the future.
And just to be clear, that committee will have a large role in the future development of noise abatement at that airport, because they will help us determine where we put our noise monitors. They will be evaluating some of the measures that we recommend for further study, determine whether or not it's feasible to even recommend moving forward with those with the Board of County Commissioners. So there's a lot of work to be done by that committee, but again, I feel like that's probably the most significant thing that will come out of the noise abatement, the noise study.
Thank
Very
you,
good.
Director Beebe.
Thank you. I look forward to it.
So with that being said, the district commissioners, one with the actual airport and one with the residents, support, it sounds like, what is in your presentation of moving forward and bringing back to us the committee, the monitoring systems, the 6 different abatement issues, and so on. So we look forward to seeing that in the future. So thank you so much, everyone.
Thank you.
I'm going to move on to board direction. Does anyone have board direction? Without seeing any, do we have any commissioner comments? Commissioner Flores, you are recognized.
I just want to wish the mayor a happy birthday. So congratulations, Mayor. I know you had a birthday yesterday. I hope that you spend it with your family and you enjoy your day.
Thank you so much. Commissioner Weiss, you're recognized.
Yes, I'd like to request an off-site proclamation celebrating 100 years of Temple Bethel in West Palm Beach.
I have a motion. Do I have a second? I have a second by Vice Mayor Woodward. All in favor? Any opposed? See that that motion carries 7-0. Clerk, are you with us? We had a motion by Commissioner Weiss, and we had a second by Vice Mayor Woodward, and it passed 7-0 for an off-site proclamation. Next, Commissioner Sachs, you're recognized.
I also want to wish the mayor a very happy birthday, and hope that she enjoys it with family and friends. Enjoy.
Thank you so much. I have one for my own. I would like to request a motion to receive and file the 26 board and commission assignments.
Second.
I have a motion by Commissioner Flores, a second by Vice Mayor Woodward. All in favor? Any opposed? See that that motion carries 7-0, please. And we will move on to administrator comments.
Thank you, Madam Mayor, and of course, happy birthday as well. I do want to say that when I interviewed in front of you this summer, I talked about what we did at Clerk with career fairs and job fairs, and we are having our first ever at the county, and that has to do with the great work of our entire HR department, Deputy Administrator Tracy Ellison, who came over from the clerks. So from 3 to 7 at the Majestic Ballroom right here in West Palm Beach, 130 Australian Avenue, will be our first ever career fair for our county. Also, Madam Mayor, always bittersweet, but we have a gift from administration for our county attorney, Attorney Kaufman. If I could present it or hand it to her.
And she's back.
Yes, and she's back.
Hi.
And this does have a C on it, so I just want to.
Aw.
And this is from the entire administration.
Aw.
Very nice.
Commissioner Powell.
Thank you, Madam Mayor, and I'd also like to wish you a happy birthday.
Thank you.
Congratulations. Also, is it time, do we take a moment to, or do we wait to say something good about Attorney Kaufman?
Today's not her last day.
No, but it's my last meeting.
Last meeting? Oh. Yes. You are on, Commissioner Powell.
Well, I just want to tell you, Attorney Kaufman, it has been a pleasure working with you. Of course, you're my first county attorney. No. And it was wonderful having the opportunity to sit next to you and just gather and gain knowledge and work with you behind the scenes on some of the issues that we have up here. I'm wishing you the best in your retirement. Have a safe, fun, and enjoyable retirement. Do everything that you want to do, and just live life, enjoy, because you only get one, and we're so thankful to have had you here. I know I've only been here for a little over a year, but it has indeed, of course, been a pleasure working with you. Thank you for your service. Because a life of service is a life that counts.
Well said, Commissioner Powell. Vice Mayor Woodward, you are recognized.
Thank you. Thank you, Mayor. And I'm very sorry, I didn't realize today was your last meeting with us. This month snuck up. I'd like to also thank you for your time here, and it's been interesting. I've had 3 years with you. You were also my first county attorney, and I'd just like to thank you for the work that you've done. And please don't delete my phone number, because there's a solid chance I'll give you a little bit of time, but I'll be in touch with you again. You're a good sounding board for stuff, and hopefully you'll stay somewhat engaged with us, but I do hope you enjoy your retirement.
Commissioner Flores, you're recognized.
Denise, I just want to say thank you. Thank you for what you've done for this county. Thank you for advising me. Thank you for helping move us forward. One of the things that I can say about you, and this is even before I got sworn in here, is that you've always had the best interest of the county, and that you have always fought to preserve and to protect our residents. So on behalf of District 3 and Palm Beach County, I just want to say thank you for doing that. You're a true professional, someone with tremendous experience, and somebody who I have tons of respect for. So thank you so much. Enjoy your retirement. And same thing that Commissioner Woodward said, if you see us deviating, text us, let us know. Thank you.
Commissioner Sachs, you're recognized.
Oh, thank you so much. And Denise, you've been wonderful. You know, the mark of a good lawyer is to protect your client, and you have, in a very quiet but strong way. As an attorney to attorney, thank you for being here for us, giving us advice even when that advice may not have been that favorable to us, but that's the mark of a good lawyer, is your professionalism. Thank you, and by the way, I'm keeping your cell number in my phone, just in case. Thank you, God bless you.
Commissioner Weiss, you're recognized.
Thank you, Mayor. Denise, it's been wonderful opportunity to be able to work with you for myself. And, you know, I will miss your candid and wise counsel, which is very much appreciated and actually very much needed. I mean, that, as my colleagues have said, that is the mark of a really great lawyer and attorney, is to try and protect your clients. And sometimes you need to be forceful about that, and you have been when needed, and I very much appreciate that, and that is something I will miss from you. But I also, you know, our personal relationship of being able to work together, you're just a kind, compassionate person, and this is you know, everybody, you know, has opportunities for new chapters in their life, and this is one for you. So I certainly understand that, but you will be missed here in your Palm Beach County family, but you're always a member. Nobody ever can divorce their own family, so wish you all the best, and thank you for everything you've done in all your years of service in government.
Commissioner Marino, you're recognized.
Thank you. Denise, you're my second attorney. The first one was also Denise. Thank you so much. You know, the role of the county attorney is to represent the county, protect the board, tell us when we're making silly mistakes. Thank you for doing that, even though sometimes it might have been hard for us to take. I do appreciate you wanting to retire, spending more time with your mom. I understand that more than a lot of people know. So I wish you good health, and I wish you a good, hopefully long time with your mom still.
I will wrap up with saying thank you for your service. Thank you for being here. Thank you for listening to us. It's not always easy having 7 bosses, but you got through it. And I hope you look forward to retirement. So thank you for everything. Have a great one. Meeting adjourned.
Put it on and watch. Got it. So too.